Hello and welcome to another episode of Kick-Ass Brand Show. And today I have for you no one other than Mr. Kevin Prince, the US patent agent, the founder and CEO of QuickPatents, and also someone who indirectly, and I don't think Kevin even knows about this, someone who indirectly influenced my decision to start Trademark Factory and become what I do today. I'll tell more about this during the interview, but for now, all I want is for you to welcome Mr. Kevin Prince on the show. Thanks for being here, Kevin.
Thank you, Andrei. Appreciate it.
Tell us how you got into the whole industry, how you became a patent agent, and how you started your own company and why.
I'm an inventor, and I had some product ideas. I was right out of college. I went to work for McDonnell Douglas, which is now Boeing, building the MD-11 airplanes. And I hated it. It was 50,000 people, and it didn't matter if I was there or not. It was just frustrating, and it was time for dollars. I thought, well, the way to make it big is to get some inventions going. And so I went and found a patent agent on this idea I had in college, which was, I kept sleeping through my alarm clocks. And my idea was, why does your alarm clock try to wake you up if you're in a deep delta sleep when you can't hear the alarm? So I thought, why not have it wake you up in a range of time wherever you're at your peak? Maybe it's 20 minutes earlier, but it's a lot easier to wake up. So I found a patent agent in Irvine, California, and went in there and asked him to do a search, and he did, and he found the exact same thing. It was patented 10 years earlier. I was bummed, of course, but it was very educational reading that patent and seeing how much detail had to go into it. It was an idea that was obviously 10 years too late for me. It was probably premature for that product anyway, since you would have had to sleep with electrodes on your head, and I don't think that was real practical. So now I think they do it with your like a smartwatch. Mm-hmm. It can tell where you are in your sleep cycle. So anyway, that's how I kind of got into this. And the guy who did
but that patent is long expired, obviously.
Oh, yeah. Mm-hmm. And I didn't have to spend any more money on that project, which was good. So anyway, the guy who did the patent search for me, he was working at Lockheed, and he wanted to, he was doing this on the side. He wanted to know if I wanted to start his patent and trademark business with, just me basically as the first employee. And I thought that sounds a lot funner than what I'm doing now. So I went ahead and switched over. And in that time, I learned how to do patent searches, write patents. He would write the claims as the patent agent, and then I would write the rest of the specification. And I think I learned how to write claims from him by osmosis, just reading all of the claim sets that he wrote. And so I did that for about 4 years. I then thought, here I am telling people how to start and do their business, and I've never even done it myself. A neighbor of ours in Fountain Valley when I was growing up, he and I started a computer accessories company for the people who are, road warriors. That's what the name of our company was, Road Warrior.
Wow.
And it was for people who were running around with their laptop computers and who, would plug into the PBX line and the remote office. Or actually, we had an acoustic coupler that you could connect to a payphone, and there was such a thing as payphones. And anyway, we got that up to about 5 million in sales. And then we sold it, unfortunately, to one of these .com flameouts in 2000. And, I watched my stock price go from $26 a share down to 76 cents over the next 2 years.
Yikes.
So live and learn. But anyway, we had some successful products in that business, made a dent, and it was good. But when we were done with that, I thought, what do I want to do with my life? And I really liked working with inventors. I studied for the patent bar, took that in 2005, and I've been running QuickPatents ever since full time.
That's interesting. So I don't know if you remember this, but the reason I got to talk to you the first time around was when I just moved to Canada. I was preparing for my bar exam, and in Canada, in order to write a bar exam, you have to slave for a law firm for half a year for basically no money. They call it articling. So I was with a guy who was a commercial litigator, brilliant guy, but I very quickly realized I don't want to do any of that. And so I was sitting there with all the stacks of books and all of that stuff on my desk. And I'm like, there's got to be a better way, because I'm all about optimizing things, digitizing. And so I thought I came up with a brilliant invention, right? Which was to sell books to lawyers as not as digital format, but as PDFs, searchable PDFs.
Sure.
Like legal books to lawyers, because the two options were you either have your printed books or you have your LexisNexis, which doesn't really have pages. And in Canada, when you had to go to court, you actually had to show them what page from which book it is.
Okay.
Right? And so I thought, well, let's come up with some sort of digital delivery system that will give legal books to lawyers digital format. I'm like, this is going to be big, right? My problem, of course, was I didn't own the content. So the only way for me to monetize the idea was to see if I could get a patent on the method, right? Cool. Let's see if I can do something with it. And my initial idea was, well, why don't I find a law firm in Canada who can help me get that started? I called a few, got some quotes ranging around 10K each. And I'm like, I don't know if that's necessarily something I'm ready for at this point. And then I started doing more Google searches. I found you. And the thing that completely sold me on was the idea of, you start with a patent search. And I had the exact same experience with it that you had with your invention, because I think I paid you, what was it, $300, $500? I don't remember what it was. But you came back with a 92-page report that basically killed my idea right then and there.
That's unfortunately not uncommon.
Yeah, but I was so grateful to you that, my thinking about the idea, how much went into the process was limited at, just a brilliant idea and a few $100s that I paid you. Right? As opposed to having this big law firm file the application, then explain to me, here's how we can overcome this objection if only you pay us a little more and a little more and a little more. Right. Then I was like, and funny thing is, I wrote my PhD thesis in Russia on all areas of intellectual property, patents being one of them. And I'm like, if I had no idea how to do a proper patent search, if I didn't know how to do this stuff in real life, how are normal people supposed to figure this out? That's why they get hit by all the, crazy bills and all the problems. And I thought that what you built with QuickPatent was absolutely genius and absolutely brilliant, right? And that's why we've been having this relationship ever since. Starting with a search and, doing the rest, assuming that the stuff is even doable. So I never went into patents. I don't think I'm smart enough to do patents.
Well, about 85% of the searches we do, we find something pretty close.
Yeah.
That's how hard it is to find something, to come up with something that's truly brand new.
That's 85%. Wow. That's quite a statistic. So it's significantly better with trademarks, but it's telling, because people think that just because it's not on the shelves, just because they didn't see it on the market, then it's new, non-obvious, and patentable, and not so much.
Right. Well, I tell clients every day that the patent office wants three things to get you a patent. One, it has to be useful, and that's usually pretty easy to show.
Yeah.
The second thing is it has to be novel, which means no one's done exactly the same thing. They've not put together the same exact kind of product as what you have. Mm-hmm. And that's actually usually the case. I mean, if there was an exact product out there, it might be on the shelves. You might be able to find it on Amazon or whatnot. Mm-hmm. But then the third thing that the patent office wants is for it to be non-obvious. And what they mean by obvious is you're not just taking bits and pieces of things that already exist and slapping them together to get your product. And a lot of people get confused on that, because one piece of your invention might be on a product that's in a completely different field. It has nothing to do with what you do. And same with another piece of the product. But if you put those together structurally, the patent office can argue you have basically your idea. So the example I use to explain this is a shower radio combined with a soap dish. Okay, if you had a battery operated radio that sticks on the wall, and you wanted to make a concave portion in the top wall of the housing to hold the soap, and you sent that into the patent office, they would reject that as being obvious because the soap dish thing is doing the soap dish thing, right? It's not, there's nothing unexpected about how that's going to work. And the battery operated radio is going to do its thing. Anyone who makes enclosures, plastic enclosures for a living would know how to make a concave section in that housing and get your product. So I believe the patent office would say that's obvious, but if you turn the radio on and now it's blowing soap bubbles to the beat of the music or something like that, right? Now you have something that's not obvious because there's an interaction going on between those parts that's brand new. No one's, someone who makes plastic enclosures for a living wouldn't necessarily know how to do that. So that's kind of the level that the patent office wants to see before they're going to issue you a utility patent.
And the trickiest part, of course, is this argument that inventors were like, if it's so obvious, why hasn't anybody done that yet? And the patent office goes back. It's like, well, it's obvious to the people in the industry. And there's just like,
right. So
that's the murky part.
The average person thinks obvious in a different way than the patent office sees obvious. They're using the word a little differently. What the patent office assumes is that if something has been published, that everyone should know about it, right? And so if you had 2 or 3 pieces from different products that were published somewhere, it would be obvious to combine those if you knew about them. But the patent office is going to assume that you knew about them if it's published. And it can be any published document. It can be an old website. They have this archive.org. It's the Wayback Machine. And they use that a lot. So they will go look at a website from 2011. And even though that website's completely different nowadays, they'll go back to the 2011 version and find things to use against your product. So it is challenging getting it through the utility patents. I would say 95% of the time, and we're talking the U.S. Patent Office here, obviously, 95% of the time you get a rejection. Probably 75% of those or more are because of this obviousness issue. And then you have to fight with the patent office with what are called office action responses. So they'll send you an office action, which is a rejection, and then you got to respond to it. And then they might send you another one, and then you got to respond to it. And each one of those responses is 5 to 10 pages of arguments that we're making about why the examiner's wrong, in a nice way. But we're saying, look, the examiner didn't consider this, or maybe misunderstood something over here about this prior art. So anyway, there's a lot of back and forth. And then ultimately, the last statistic I saw was between 60 and 65% of all applications nationwide eventually become a patent. 35% don't. And that means that when they're rejected, you spent all this money on a patent, you get nothing but a few years of being able to say patent pending.
Right. The language that they used in patent claims is just ridiculous. I remember in my book, I had a quotation from Michael Jackson's patent on this
on his foot thing.
Yes.
Yeah, I know that one.
Just like this is not meant to be read by humans. It's worse than tax code. Have there been discussions about actually changing the language used in this?
There's all sorts of discussion, but here's the interesting thing. If you take a patent, you print it out and you hand it to some random patent attorney or patent agent, what you'll see them do is they'll look at the drawings and then they'll flip to claim 1. And claim 1, and this is because claim 1 is the most concise way of describing what this patent actually protects.
Right.
Okay. And so generally speaking, the shorter claim 1 is, the better in terms of the patent holder, how strong the patent is.
The first independent claim, yeah.
Yeah. Everything else is going to be more restrictive. So you want to look at claim 1, and that's that's going to tell you what this thing actually protects. Right. And it is hard to read it. Sometimes, even like myself, 20 years doing this, sometimes there's patent practitioners that write it so muddled, and it's very difficult to figure out. And I think that's sometimes on purpose because they want something to argue in court. I've always preferred writing claims very clearly so that you know what it is that's being protected. And you start to get used to the language, and it's really good for inventors to read claims, and certainly to read claims on their own patent before they send it in. Yeah. Just to make sure. There's 2 issues that people get confused. One is patentability, and the other is infringement.
Yeah.
And these are two different things, but it's there. Sometimes there's overlap, and so it's a little confusing sometimes. The question of patentability, and that's why when I did the search for you, the question is, if we file an application on your invention at the patent office, what's going to happen? Are they going to reject it, or are they going to approve it?
Mm-hmm.
And that's a different question than, hey, here's a patent that we found in the search. Am I infringing this patent?
Mm-hmm.
Okay. And so what I tell people is, and this sounds crazy, but the patent office doesn't really care about infringement. They leave that to the courts. The patent office cares more about patentability. Should they issue a patent on this thing?
Right.
And so if there's a patent that has elements, let's say in claim 1, there's a patent that has elements A, B, and C, and you've come along and made element D, some improvement to this device. And D is brand new. No one's ever done D before.
Mm-hmm.
Well, if you send that into the patent office, they'll give you the patent on it because D is brand new. And, congratulations, you get your patent.
Mm-hmm.
The problem is you have to make A, B, C, which violates this other patent.
Right.
And D. Right now, the people who have the ABC patent cannot make D because that would violate your patent.
Yeah.
But ABC might still be covered. And so the patent office will issue a patent even if making this thing infringes another patent. And that sounds crazy. People are like, how can that be? But it's the way it works. Sometimes you could do a cross license with the other people who have the ABC patent, or sometimes you might license yours to them and then they can make the ABCD. So there's different things that you can do thinking outside the box. The other thing is you can wait until the ABC patent expires. It's got 20 years from the filing date.
So 20 years from the filing date. How long does it typically take from the filing date till the date when you're holding your patent certificate?
It can be 1.5 to 3 years.
Really? I think it used to be higher, like close to 4 or 5, no?
Well, if you have software, there's certain fields that it does take longer. It can be 4 or 5 years.
Yeah.
I just got one that was 7 years.
Wow.
And the reason it was 7 years, it was software. This is going to make anyone who has filed a patent pull their hair out, because at the patent office, if you get assigned to an examiner that's difficult, you can't do anything about it.
Yeah.
And so we filed this patent that I'm thinking about in 2014. The examiner assigned to it rejected it, of course. And so we wrote back a good response, I thought. And I knew this thing was patentable based on the prior art that he found. So we adjusted our claims and we sent it back, and he rejected it again. And then when you get a final rejection after the second one, you can call him and do an examiner interview. And so we did that. And he was very cordial, very nice, understood our points and seemed to agree with us based on that feedback, sent in another response, and he rejected it. Well, about that time, I found a service that lets you have to subscribe to it, but it shows you what the statistics are on the examiners, their allowance rate. So I looked this guy up, and guess what? Over 3 years, his allowance rate was 0.
Jesus. Wow.
0 after 3 years. And so I'm like, he just doesn't think that you're allowed to allow these applications or something. His art unit that he was assigned to, that's the group that's the basic same technology. So all the patents that are in the same field go into this art unit. Right. And they might have 10 or 12, examiners in that art unit. His art unit, the allowance rate was 73% or something like that, much more in keeping with what the standard, the overall allowance rate is. Mm-hmm. But he was a 0. Mm-hmm. And so we ended up having to respond to his rejections 6 times. That's the max.
Wow.
So you can file, after 2, which is what your filing fee pays for, you have to pay for a request for continued examination. And then you get another couple rounds with the examiner. And then you can file a second RCE, request for continued examination. Anyway, we did the whole process. And at the very end, we were able to appeal it to the Patent Trials and Appeals Board. And that's another whole 2-year process, right? And lots of money. But the Patent Trials and Appeals Board agreed with us. And I knew they would, because this thing was absolutely patentable.
Yeah.
And so they kicked it back to the examiner and said, issue it. And so we just got it. I think it was last year that we got that one through. So anyway, it can be, that's like the worst case scenario, Was
the technology still viable at the time they got the patent?
Yeah, it had to do with adjusting fonts on the fly based on the letters next to them for readability. It was a really cool concept. And
they ended up only having 13 years of useful life out of this. That's interesting.
Well, I think that, so if it takes inordinately long for the application to be published, they'll give you extra days. Right? So, because they know that's not really fair. On the last patent I got for myself, I think I had an extra year and a half or something that they gave me because it, took them a long time to issue it. Yeah. So if you look on the front page of a patent, it'll say the term of this patent is extended by 576 days or whatever they calculate. And that's different than design patents because design patents are 15 years from the issue date. So it doesn't matter how long it takes them to get it. Once they issue it, it's 15 years. And that's one thing I like about design patents is there's no maintenance fees.
So unlike trademarks, you cannot renew a patent, neither design patent nor utility patent.
Correct.
Once it expires,
it's a limited monopoly and it's limited in time. What I tell clients is, you got your 15 to 20 years to build up your brand so that 30 years from now, people are still asking for your brand name, even though there's competitors who are able to make the same thing because your product went into the public domain.
And that's where trademarks come in. So you got exactly this limited monopoly to build up a brand that you own. So by the time your patent is dead, you still own something. So I think we got carried away a little bit. So I want to go back to step one. Yeah. So we talked about all these details about patents, which I think, could you, for lay people, explain what is actually an invention, right? And what people sometimes think is an invention.
Right. Well, so let me talk about the two basic types of patents because there's basically design patents and utility patents. When people are talking about patents, most of the time they're talking about utility patents. A utility patent protects your invention, which is an apparatus, like this pair of scissors is an apparatus or a device or something like that, something tangible. It's an article of manufacture. You can also protect a method, and a method is, for example, a method of making something. So if you go into Starbucks and you get one of their little cardboard coffee cup sleeves, if you look on the back, I don't know if they're still putting the patent numbers on there, but on the back, they used to have a couple of patent numbers, and you look those up. Those were not patents on the physical sleeve itself. They were patent on the method of manufacturing the sleeve. And so in theory, if someone could come up with a different way of manufacturing the same thing, they would get around that patent because it's not protecting the device itself, it's protecting the way that that particular manufacturer made the device. All software patents are method patents. They're talking about the steps that the CPU goes through in its, doing whatever it's going to do. Or a business method is also a method patent. It's protecting the steps. Like Netflix, the original Netflix patents had the steps of, establishing a user account, asking the user for a queue of DVDs, shipping the first DVD on the queue to the customer, waiting for the customer to send back the DVD, sending them the next one in the queue, and so on. And so that was a list of steps. And some utility patents, you can do both. You can say, I want to protect the apparatus itself and the method of making. So we've done that a number of times too. I think the thing that people most confuse with patents is something like the slogan that you would put on your T-shirt. Like they'll come to me, and so that kind of shows a little bit where there's overlap between copyright and design patents. Design patents protect a design, a shape, the ornamental appearance. So like in this, well, there you go. Yeah, see, that would be a design patent, right?
Yeah.
And the design patent, we wouldn't be showing blue necessarily. We would do black and white line art drawings, but we would show that distinct column on the left, right, with the stripes.
Yeah.
And maybe some of the stripes we put in broken lines so that, it can be optional. So there's things we can do with that. But the graphic artwork that you put onto a T-shirt is actually more appropriate as a copyright.
Copyright, yeah.
And then if you're going to call it, old guy's rule, and you're going to make a line of these things, then you call Andrei because that's a trademark issue. Oftentimes people will come to me with something that really should be a trademark or a design or a copyright. You got to make sure that they're going in the right direction.
One thing I found, I was fascinated about this idea about professional knowledge, that if the method relies on a professional doing something, that it's usually not patentable. And oftentimes, like all the courses, all the people who sell their information, and they're like, "Hey, can I patent this so that nobody can teach the same thing?" What would you tell them? Because that's one of the common questions we get all the time.
Yeah, that kind of goes into the whole concept of what they call a mental step, right? If you're trying to protect something that's done mentally, you can't protect that. And so here's the interesting thing: Monopoly, probably best-selling board game ever, got a patent back in 1930, 1940, whatever it was, and at the time the laws were different. And now there were a couple of Supreme Court cases called Bilski and Alice. I don't think you could get a patent on a board game anymore, because there has to be a transformation of the physical apparatus itself. And when you put the game back into the box after playing it, all the pieces, if they're the same, or there's not been something that's changed, then you're probably not going to get that patent. And it was weird because I had a couple of patents, one for a gambling game, and we were able to get the computer version of that game patented, but not the physical version, because that's right when this case came out, and it was kind of strange. And it really threw a wrench in a lot of the software patents. A lot of the software patents started getting rejected. And now they've kind of figured out different ways to word it and how to tie it into non-volatile memory and things like this that you have to put into patent now. But it's kind of a change. Patent law, just like trademark law, is changing. And every once in a while, you'll get a decision out of the Supreme Court where you have to adjust what you're doing.
Yeah. If you are talking to a small business owner, someone who came up with an idea, they think it's novel, they think it's not obvious, they think it's useful, obviously. If they're thinking about patenting, maybe, they're making a couple $100,000 a year on this, who would you say should consider a patent? What should they have to even think of in this direction? And who of them should be like, don't worry, work on your brand, work on your profits, work on, getting known, and don't worry about trying to protect the invention? How would you answer them?
Obviously, a lot of this comes down to budget, what they have available. A lot of it comes down to the nature of their product, what they're trying to protect. Is it something that's even patentable? If it's just a new line of T-shirts, you're probably not looking at patents. You're really looking at building a brand and really trying to do good marketing, trying to be the best, the first with the most out there. If you have something that might be patentable, I'd say call a patent practitioner like myself. I'm a patent agent, so I'm an engineer. They let me practice law in this one little area called patent prosecution, or call a patent attorney and just find out, is this the kind of thing that could be patented in theory? Is it patentable subject matter? And if it is, I think it's probably worth doing a search, right? You can, at least that way, you can get an idea of what the landscape looks like, who else is out there, what kinds of things have been patented in this field before. You might learn about some competitors you didn't know about. So there's a lot of good reasons to do a patentability search just to see where you fall. In fact, I have a saying that the patent or that the inventing doesn't really start until you get your patent search back, because then you know where the holes are, and maybe that'll stimulate something. You'll go, oh, wait a minute, this guy's doing it this way, but I bet we could do it this way, and that make it more efficient and get a patent on it. So I think a patent search is almost a no-brainer. I mean, we charge $4.99. I think attorneys probably charge over $1,000 now. As a patent agent, my overhead isn't as big, so I can charge less. But if that's too much money, we even have a class online to teach you how to do your own thorough patent search using Google Patents. The class is $50. It's on Udemy, so udemy.com. If you search on "Do It Yourself Patent Search," you'll find my name will be on it, and you can click through.
Yeah, we'll find the link. We'll put it in the
right. And see, what most people do, they do a search on keywords. Everyone knows to do a keyword search. That's not enough, because patent practitioners, and like you kind of mentioned, sometimes they on purpose use strange words that the average person wouldn't think of. You need to do a patent search with keywords first to get an idea of where you're going to be searching. But then you also have to search on what are called class and subclass. And the Patent Office classifies patents based on the subject matter. And so if you call it a widget, and someone else calls it a gizmo, in theory, it should still be in the same subclass because that's what it does. The patent office takes a lot of care to classify their patents in the right spot. And so then you just look through all the patents in that classification and see if there's any that you missed with the keyword search. Okay. And then the third and final thing that you have to search to do a thorough search is on the A-list patents, which came up with this kind of concept of A-list and B-list on your patent search. The A-list, when you get your patent search back from us, the A-list has the most relevant patents, and the B-list has maybe 4 times that number of patents, but they're not as a direct hit, right? They're kind of in the periphery of what you're doing. Maybe they have 1 or 2 similar features, but they don't have everything that you have. So those A-list patents are the most relevant. And then what we do to finalize the search is we do what's called a forward and backward reference search. And on a patent, on the front page of the patent, you'll see a list of patents that the patent examiner found when doing the examination. And that's actually the patent search for that application, right? The examiner does the search, very good search. They have access to everything. And that's what they found when they searched on this patent. And what they found was not enough to stop this patent from going through. So what you have is basically backward in time, a list of the most relevant patents to this one, right? And so if this application, call it application A or patent A, is similar to your concept, then the backward references might also be similar. Okay, so it's important to search those, right. Type in those patent numbers. And then the forward references are any more recent patents to patent A have patent A on their front pages. Right? So maybe one that came out last week has patent A on it. Well, you better check that one because it might be, in fact, exactly like what you're trying to do.
Right.
And so if you can do a search on keywords, class and subclass, and forward and backward references, that's a pretty good search. And you should be prepared to spend 8 to 12 hours your first time doing it. After we get up to speed, and I was doing 4 or 5 patent searches a day at one point for LegalZoom. We were getting pretty fast. I was doing them in like 2.5, 3 hours. It's really, when you're trained on how to do that, you can kind of decrease the time. But your first ones are going to take a while. But if you're prolific, I would definitely learn how to do your own searching, because if you have 20 ideas, you don't want to pay $500 even on the low end to us to do the search. If you can do it yourself, at least eliminate the 18 of those ideas that have already been done, right?
So you mentioned having a conversation with a patent agent or attorney to decide whether you're even in the realm of something that's patentable. I remember back in the day when I used your firm, you were offering, I think it was a 30-minute free consult with you. Is that something you still offer? Is it something that people who watch this interview could take advantage of?
I think it's probably pretty common for attorneys to give some kind of an initial consultation for free. I know that often, we are talking with people, and for various reasons, we end up not doing anything with them because it's not appropriate. So I'm happy to talk with people about their ideas. I've got slots every day of the week, and you can just pick one on my electronic calendar, and then at that time we'll do a Zoom call like this, or we'll do a phone call, whatever it takes.
What I liked back in the day, you had this electronic NDA because obviously everyone thinks they came up with the most genius idea that everyone's just waiting to steal. And, with all the horror stories about some bad agents in the market who take advantage of the inventors, I really like how you make it really easy for people to disclose, to actually have an open conversation with you. I thought it was.
Well, there's, it's interesting. One of my clients was suing someone for infringement, and the opposite side attacked my ability to have attorney-client privilege conversations with the client. They wanted all my back and forth emails with the client. That case actually kind of cemented the fact that you have attorney-client privilege when you're working with a patent agent, just like an attorney.
Yeah.
Because that was the intent of Congress, right? And so on one hand, when you're dealing with any practitioner, you have attorney-client privilege. So technically, a non-disclosure agreement is a little bit redundant. And a lot of patent attorneys won't sign them. They just say, well, it's redundant. You already have attorney-client privilege when you're talking to me. I'm okay with signing non-disclosure agreements, though, because I think it's a good habit for people to get into to ask for it, right?
Yeah.
And I have one on my website. You could just click a few buttons. And then when I get it in my email, I click a button and it goes back to you with my signature on it. And so, so I'm happy to sign them. And that brings up something, a lot of people think, well, I'm scared that my patent attorney is going to steal my idea. Rock bottom truth is patent attorneys wouldn't know how to market your idea if it was right in front of them. Because so people who, generally speaking, and there's a lot of scams in this industry. I'm not saying there's not, but generally speaking, the people who have services for inventors are not who you have to fear, because if they get a bad reputation, they're out of business. I mean, you know how many one-star Yelp reviews and then the guy's in trouble, right?
I think one of the things that a lot of people don't understand about patents is once they've disclosed their invention to the public, unless they act quickly on it, in the US there's grace period, in most countries there isn't, killing their ability to patent their stuff in the world. Could you talk about this? Because a lot of people they will be afraid to talk to a patent agent, but they will be very happy to give interviews and post stuff on Facebook.
So in the United States and a few other countries, a thing called a grace period. And that is the time between when you publicly disclose your invention and when you have to file your patents. Most countries don't have a grace period. They have what's called an absolute novelty requirement. Mm-hmm. And if you've disclosed your invention even yesterday, and then you file your patent, it's too late. Like China, for example, doesn't have a grace period. So in the United States, at least, if you publicly disclose your invention, you do have some time to file your patents. The reason that we do that is because patents are expensive. And, if you have a product that you've launched, you don't really know if it's going to be a hit or not. And so if it's not, then you don't have to bother with spending the money on a patent. But if it is a big hit, then yes, you should probably pursue patent protection. Now, the problem with disclosing it first is, for example, putting up a listing on Amazon or publishing a YouTube video that shows how to use your product or how to install your product, something like that. The problem with doing that before you file your patent in the United States is that you'll lose most of your foreign filing rights. And maybe you don't care about foreign patents, that's fine, but maybe you want to keep the option open for a year. Because who knows, maybe a big company will see your product and go, hey, we'd like to really take this around the world. What are your patent rights? And if you have to say that you've given up your foreign rights, that may be a detriment in your negotiations, right?
Yeah.
So, and my advice also is you don't want to publicly disclose something for too long before you file your patent, because as of 2013 and the America Invents Act, we're on a first to file system now. In the United States. Used to be we were on a first to invent. If you could prove that you were the first inventor, even if you were the second or third person filing the patent, you could still get the patent. But now they don't care. It's whoever files the patent first. They just want to look at a date stamp from the mailroom. When did we receive this? Yeah. And that's who gets the patent, whoever filed it first. So it is a bit of a race if there's multiple people inventing in this space. And for that reason alone, I would say you don't want to wait too long. If you're forced to publicly disclose it, you probably should work on getting your patent filed as soon as possible if you're going to file a patent. Now, here's the thing. Your invention is going to go into the public domain at some point. Mm-hmm. The question is when. If you launch the product and you wait more than a year and that grace period expires, then your invention has gone into the public domain. Anybody is free to make and use your product. If you file a patent, you may get 15 or 20 years of a monopoly, but then it's still going to go into the public domain.
Yep.
Okay. So the example I use for that is my ex-business partner is one of the guys who co-invented Silly String. And this was back in the 70s. He was trying to figure out a way to make it easier to pick, pack, and ship products so that you would just squirt this stuff into a box on the conveyor belt, close it up, and it would kind of foam up and protect the contents during shipping. He hated those shipping peanuts that get everywhere, right? Mm-hmm. And so he was trying to figure out, how to make something that did that. And he discovered that it was a lot more fun to squirt people with this stuff, right? And so he ended up licensing the product to Whammo. and they were, obviously Silly String's was a huge success.
Mhm.
And in the mid 90s, I think it was, the patent expired. So now if you go into a party store, you'll see Silly String on the counter. It won't say Silly String because that's still a trademark registered by WAMO. It'll say like string confetti or confetti in a can or something like that. They can't call it Silly String, but it's the same exact stuff. And so that's a good example of what you were saying,
Yeah.
how you use that time to build a brand. Because if you go in and ask for Silly String and they happen to be selling Silly String, that's what you'll get.
What's your opinion on provisional patents? So they exist in the US, and I know a lot of people misunderstand, they confuse provisional patents with patent pending. Like, walk us through this, and are provisional patents useful, useless? What do you think of them?
Provisional patents are relatively new. I think they were introduced in '94. I mean, that might not sound that new anymore, I guess, but a provisional patent is basically a disclosure of how to make and how to use your product, and it doesn't have to follow the same format as a regular non-provisional application, what a lot of people call a regular patent. Right? A provisional patent is temporary. It allows you to say patent pending on what you've described for a year. And I like to think of it as a placeholder in line at the patent office, right? So if there's a patent to be had for this thing and you're first in line with a provisional, then presumably when you file the non-provisional, if you were first in line, you'll be the one that gets that patent when the non-provisional is examined. So there's two advantages to the provisional and one drawback. And they're pretty simple. With the provisional, it's usually less money up front, right? So from a cash flow standpoint, I'll just use our firm's prices as an example. We charge $2,500 to file, to prepare and file your provisional application. That allows you to legally say patent pending for up to a year. And the filing fee is going to be $75 or $150, depending on if you're a micro entity or a small entity. Almost all of my clients are either micro entity or small entity. I think I have 2 large entity clients. So that's, I mean, in my business, I'm focused more on the independent, small businessman, independent inventor.
That's who's watching this video. Yeah.
Okay. So that's one advantage, is it's less money up front, even though it'll be about the same on the back end, and we do things a little differently than most attorneys. If I'm writing your provisional application for $2,500, a year later, when it comes time to file your non-provisional application, I don't charge you the full price for that, which is $4,500. I just charge you the difference, which is $2,000.
Okay.
So that kind of has the effect of spreading the cost out over the year. So that alone might be one reason why you want to file the provisional. The other reason is because with a provisional, you do not have anything that's in line to be examined yet at the patent office. And so you can make changes. And when I say make changes, I mean make improvements. So let's say 3 months after you file your provisional, you think, something dawns on you and you think, I know, I'm going to add LEDs to this and make this really cool. And so what we can do is we can just add the LEDs and some more drawings to your existing application, file it for $75, and now you have that new feature also protected. Okay? So it's easier to make improvements, and we can roll all of those improvements up into the final non-provisional application a year later, and make sure that those are all ready to go and get examined, in due course at the patent office. So those are the two advantages: price up front, even though it ends up being about the same on the back end, and it gives you some time to make improvements without having to go through a lot of expense at the patent office to file additional patents, which is what you would have to do if you filed the non-provisional.
And you said there's one drawback.
There is one drawback, and that drawback is what I kind of alluded to earlier. Nothing happens at the patent office with your provisional application. It goes in as a placeholder in line, and they look for a few technical things, like to make sure that if you said there's 8 drawings, there's in fact 8 drawings. But they're not going to do any kind of examination on the merits of the invention. They don't do any kind of prior art search, nothing. So it just sits there waiting for you to file the non-provisional. And then when you file the non-provisional, then you get in line for an examination. And it's only after the examination that your application becomes a patent. And so the provisional delays the issuance of your patent by however many months you're going to wait. You don't have to wait the 12 months. You can file a non-provisional 6 months later
Right.
But your patent will be delayed 6 months because nothing's happening at the patent office with it. You're not even in line for the examination yet at that point. And so that may be important if you're worried about people knocking off your product, right?
Right.
I had a client who he did a rush through our office, and then he wanted to do a rush through the patent office, which you can pay more money to the patent office and they'll move you to the front of the line. It's just expensive, but they'll do it. And so that's what he wanted to do because he was going to go on DirecTV with his product, which was a grill cleaning robot. It's like a Roomba for your barbecue grill.
Wow.
And it's, it walks around with these brass brushes and, for 30 minutes or whatever, cleans your grill. I have one. It's great. He's been doing really well on Sharper Image and, some of those places. So it's called GrillBot. Anyway, he wanted to speed it up because he was worried that one of these DirecTV companies was going to knock him off. Right. Because there's certain industries, they don't care about your patent pending, right? They're in and out of the market so fast that patent is probably not going to issue.
Can you enforce your patent rights before your patent is granted? So when you send that cease and desist letter to someone you think will be infringing on your patent once it's issued, like what stops them from just ignoring it and say, let's wait till it gets there?
Right. Well, so if you're patent pending, here's my analogy. I like to think of patent pending, which means you've filed some kind of patent at the patent office, design, provisional or non-provisional utility, it doesn't matter. As soon as you file an application, you can legally say patent pending. I like to think of that as a big no trespassing sign on a piece of property that you don't own yet. Okay, so hopefully that no trespassing sign will scare competitors away. Why would they want to tool up and start spending money if you're just going to be able to take this away from them in a year or two?
Right.
If somebody does set up a lemonade stand on your property, you won't be able to legally evict them until you own the deed to the property, until the patent actually issues.
And 2 years later, when you own it, can you sue them for having trespassed 2 years ago?
Only if you do one thing. And this is starting getting into the weeds. But if you're patent pending with a non-provisional application, you filed and it's getting ready to be examined, maybe it's going to be a 1.5 to 3 years down the road, you don't know. And you see a competitor show up on the marketplace and you think he's infringing the claims that you asked for in that patent application. You can have the patent office publish your patent application, even though it hasn't been examined yet. They do this, by the way, by default at 18 months. So 18 months after you file your application, by default, they're going to publish it. Now, I always opt out of it being published. Most attorneys don't opt out. I don't know why they don't, because you're basically showing the world what you're asking the patent office for, and you haven't even gotten the patent yet.
Right.
So the one time that you have to have it published is if you're filing foreign patents. In that case, you have to have it published by treaty. If you're not going to go with foreign patents, you can keep it a secret. Now, most people don't. And in this case, if you have a competitor come up, maybe you don't want to keep it a secret, because what you have to do is you have to let the patent office publish your application. When they publish it, which the fastest they can do is about 4 months after you tell them, hey, please publish this. It takes them 4 months. Okay, once that 4 months has gone by and you have a publication date that's today or in the past, you can then write a letter. It's not a cease and desist letter. It's a letter that says, hey, we're putting you on notice. We believe that your product XYZ is infringing the claims on our patent application, which is still pending, but it's published and here it is. Okay. Date that you write that letter to them is the date that your damages can start retroactively when your patent finally issues 3 years from now. If you don't send them a letter and you don't let your application be published, then you don't have access to those retroactive damages. It's a little bit in the weeds, like I said, but it is possible if you did pick up a competitor. And at that point, you might also want to just go ahead and file another application. You have to tell them you want it to speed up when you're filing it. So it might be worth the money. Right. It's like $1,000 extra for a micro entity and $2,000 for a small entity.
It's funny. It's probably been one of the longer interviews I've done for this, but it just flew by. It's such an interesting conversation, Kevin.
Well, yeah.
Why should people consider QuickPatents versus anyone else who offers the service?
Right. Well, I think the big reason is I'm an inventor myself. I played the game with the high-priced attorney. We used a very large firm in California In fact, I was working with a founding member of that firm. He was great. I mean, he was really knowledgeable and everything, but it's just left a bad taste in my mouth. I decided when I was setting up my own firm, I wanted to have flat fee pricing. This concept of, I call you and talk for 7 minutes and get a bill for $50. I was just not into that. And I don't think that really serves the independent inventor or the small business. Maybe if you're a big business, you can just write all that off, that's fine. But in my world, where I'm an independent inventor, I need to be conscious of that. So fixed fee pricing was something I wanted to have. The other thing is, I'm an engineer out of Berkeley and studied industrial engineering, which was interestingly, I wasn't planning on going into this field, but it served me very well because it gave me a little bit of knowledge in a whole bunch of different engineering fields. Mm-hmm. So I have broad knowledge. I'm not really deep on like nuclear engineering or something, but I can at least understand your concepts and write the patent. And in fact, I just did a patent for a new type of nuclear reactor. That I had to dig up some stuff from physics, but so being an inventor myself, I guess I can empathize with people who are in that position. I understand what's important to you, certainly about, getting a quality patent, but not breaking the bank. If you're spending 5 figures for a patent, I don't think that's necessary. Even a complex patent. Our complex patent, which would be like software or something like that, is $5,500, which is quite a bit less than most attorneys.
It's very reasonable compared to some of the other firms I know. Yeah,
my goal really is to see your product be successful. And people ask me, "What do you think about marketing this or that?" And I'll tell them, "Look, no one pays me for my marketing advice, but I'll tell you everything I know about patents." And I think it's led a lot of people in the right direction, and hopefully it's helped them, be successful.
Thank you. And this is a perfect segue for stuff I hinted at in the beginning when I said that me dealing with you back when I was in Canadian law school really gave me one of the sources for the ideas for Trademark Factory. Flat fee, that attitude that you have towards your clients, toward inventors, and just giving them an easily understandable way of getting what they want, or basically telling them that you can't deliver it to them without just taking their money and doing nothing. I remember when I, got my lawyer license and started looking for clients, and I'm like, maybe there's something to trademarking law, to IP law, other than just being a lawyer at a law firm, right? And that's when I remembered what you were doing and your model, and this plus a bunch of other things together came to be Trademark Factory, and we've kept a relationship ever since. And I'm really grateful to you for being with me today, sharing your wisdom. And anyone who needs a patent, who considers that you've invented something that's worth owning not on the brand side, but on the side of the actual invention, whether it's the method or the apparatus, the stuff, or how do we make stuff. If there's something unique about this, I'm just dumbing this down as much as I can. Then give Kevin a call and see how he can help you. And we can help you with the brand. Kevin can help you with your patents. And thanks for being with me, Kevin. That was probably one of the most educational interviews we've had on Kick-Ass Brand Show. Good. Hope you've enjoyed it. Post your comment below if you liked it. Ask any questions. I might be able to forward them to Kevin if you prefer to post questions in the comments rather than contacting Kevin directly. Subscribe to the channel, like this video, and I'll see you in the next video.